International Convention for the Suppression of Acts of Nuclear Terrorism, adopted by the General Assembly of the United Nations on the 13th of April 2005. In force on the 7th of July 2007, UN. Dog. A/Re/59/290, Annex, Depository, Secretary-General of the United Nations. The states parties to this convention, having in mind the purposes and principles of the Charter of the United Nations concerning the maintenance of international peace and security and the promotion of good neighborliness and friendly relations and cooperation among states. Recalling the declaration on the occasion of the 50th anniversary of the United Nations of the 24th of October 1995, recognizing the right of all states to develop and apply nuclear energy for peaceful purposes and their legitimate interests in the potential benefits to be derived from the peaceful application of nuclear energy. Bearing in mind the Convention on the Physical Protection of Nuclear Material of 1980. Deeply concerned about the worldwide escalation of acts of terrorism in all its forms and manifestations. Recalling the Declaration on Measures to Eliminate International Terrorism annexed to General Assembly Resolution 4960 of 9 December 1994, in which, inter alia, the states members of the United Nations solemnly reaffirm their unequivocal condemnation of all acts, methods and practices of terrorism as criminal and unjustifiable, wherever and by whomever committed, including those which jeopardize the friendly relations among states and peoples and threaten the territorial integrity and security of states. Noting that the declaration also encouraged states to review urgently the scope of the existing international legal provisions on the prevention, repression and elimination of terrorism in all its forms and manifestations, with the aim of ensuring that there is a comprehensive legal framework covering all aspects of the matter. Recalling General Assembly Resolution 51-210 of the 17th of December 1996 and the declaration to supplement the 1994 Declaration on Measures to Eliminate International Terrorism annexed thereto. Recalling also that, pursuant to General Assembly Resolution 51-210, an ad hoc committee was established to elaborate, inter alia, an international convention for the suppression of acts of nuclear terrorism to supplement related existing international instruments. Noting that acts of nuclear terrorism may result in the gravest consequences and may pose a threat to international peace and security. Noting also that existing multilateral legal provisions do not adequately address those attacks. Being convinced of the urgent need to enhance international cooperation between states in devising and adopting effective and practical measures for the prevention of such acts of terrorism and for the prosecution and punishment of their perpetrators. Noting that the activities of military forces of states are governed by rules of international law outside of the framework of this convention and that the exclusion of certain actions from the coverage of this convention does not condone nor make lawful otherwise unlawful acts, or preclude prosecution under other laws. Have agreed as follows. Article 1. For the purposes of this convention. 1. Radioactive material means nuclear material and other radioactive substances which contain nuclides which undergo spontaneous disintegration, a process accompanied by emission of one or more types of ionizing radiation, such as alpha, beta, neutron particles and gamma rays, and which may, owing to their radiological or fissile properties, cause death, serious bodily injury or substantial damage to property or to the environment. 2. Nuclear material means plutonium, except that with isotropic concentration exceeding 80% in plutonium-238 uranium-233 uranium enriched in the isotope 235 or 233 uranium containing the mixture of isotopes as occurring in nature other than in the form of or residue or any material containing one or more of the foregoing. whereby uranium enriched in the isotope 235 or 233 means uranium containing the isotope 235 or 233 or both in an amount such that the abundance ratio of the sum of these isotopes to the isotope 238 is greater than the ratio of the isotope 235 to the isotope 238 occurring in nature. 3. Nuclear facility means a. Any nuclear reactor, including reactors installed on vessels, vehicles, aircraft or space objects for use as an energy source in order to propel such vessels, vehicles, aircraft or space objects or for any other purpose. b. Any plant or conveyance being used for the production, storage, processing or transport of radioactive material. 4. Device means a. Any nuclear explosive device or b. Any radioactive material dispersal or radiation-emitting device which may, owing to its radiological properties, cause death, serious bodily injury or substantial damage to property or to the environment. 5. State or government facility includes any permanent or temporary facility or conveyance that is used or occupied by representatives of a state, members of a government, the legislature or the judiciary or by officials or employees of a state or any other public authority or entity or by employees or officials of an intergovernmental organization in connection with their official duties. 6. Military forces of a state means the armed forces of a state which are organized, trained and equipped under its internal law for the primary purpose of national defense or security and persons acting in support of those armed forces who are under their formal command, control and responsibility. Article 2. 1. Any person commits an offense within the meaning of this convention if that person unlawfully and intentionally a. Possesses radioactive material or makes or possesses a device I. with the intent to cause death or serious bodily injury or 2. with the intent to cause substantial damage to property or to the environment. b. Uses in any way radioactive material or a device, or uses or damages a nuclear facility in a manner which releases or risks the release of radioactive material I. with the intent to cause death or serious bodily injury or 2. with the intent to cause substantial damage to property or to the environment or 3. with the intent to compel a natural or legal person, an international organization or a state to do or refrain from doing an act. 2. Any person also commits an offense if that person a. threatens, under circumstances which indicate the credibility of the threat, to commit an offense as set forth in paragraph 1b of the present article or b. demands unlawfully and intentionally radioactive material, a device or a nuclear facility by threat, under circumstances which indicate the credibility of the threat, or by use of force. 3. Any person also commits an offense if that person attempts to commit an offense as set forth in paragraph 1 of the present article. 4. Any person also commits an offense if that person a. participates as an accomplice in an offense as set forth in paragraph 1, 2 or 3 of the present article or b. organizes or directs others to commit an offense as set forth in paragraph 1, 2 or 3 of the present article or c. in any other way contributes to the commission of one or more offenses as set forth in paragraph 1, 2 or 3 of the present article by a group of persons acting with a common purpose. Such contribution shall be intentional and either be made with the aim of furthering the general criminal activity or purpose of the group or be made in the knowledge of the intention of the group to commit the offense or offenses concerned. Article 3. This convention shall not apply where the offense is committed within a single state, the alleged offender and the victims are nationals of that state, the alleged offender is found in the territory of that state and no other state has a basis under Article 9, paragraph 1 or 2, to exercise jurisdiction, except that the provisions of Articles 7, 12, 14, 15, 16 and 17 shall, as appropriate, apply in those cases. Article 4, 1. Nothing in this convention shall affect the rights, obligations and responsibilities of states and individuals under international law, in particular the purposes and principles of the Charter of the United Nations and international humanitarian law. 2. The activities of armed forces during an armed conflict, as those terms are understood under international humanitarian law, which are governed by that law are not governed by this convention, and the activities undertaken by military forces of a state in the exercise of their official duties, inasmuch as they are governed by other rules of international law, and not governed by this convention. 3. The provisions of paragraph 2 of the present article shall not be interpreted as condoning or making lawful otherwise unlawful acts, or precluding prosecution under other laws. 4. This convention does not address, nor can it be interpreted as addressing, in any way, the issue of the legality of the use or threat of use of nuclear weapons by states. Article 5. Each state party shall adopt such measures as may be necessary, a. to establish as criminal offences under its national law the offences set forth in Article 2, b. to make those offences punishable by appropriate penalties which take into account the grave nature of these offences. Article 6. Each state party shall adopt such measures as may be necessary, including, where appropriate, domestic legislation, to ensure that criminal acts within the scope of this convention, in particular where they are intended or calculated to provoke a state of terror in the general public or in a group of persons or particular persons, are under no circumstances justifiable by considerations of a political, philosophical, ideological, racial, ethnic, religious or other similar nature and are punished by penalties consistent with their grave nature. Article 7. 1. States parties shall cooperate by a. taking all practicable measures, including, if necessary, adapting their national law, to prevent and counter preparations in their respective territories for the commission within or outside their territories of the offences set forth in Article 2, including measures to prohibit in their territories illegal activities of persons, groups and organizations that encourage, instigate, organize, knowingly finance or knowingly provide technical assistance or information or engage in the perpetration of those offenses. b. Exchanging accurate and verified information in accordance with their national law and in the manner and subject to the conditions specified herein, and coordinating administrative and other measures taken as appropriate to detect, prevent, suppress and investigate the offences set forth in Article 2 and also in order to institute criminal proceedings against persons alleged to have committed those crimes. In particular, a state party shall take appropriate measures in order to inform without delay the other states referred to in Article 9 in respect of the commission of the offences set forth in Article 2 as well as preparations to commit such offences about which it has learned, and also to inform, where appropriate, international organizations. 2. States parties shall take appropriate measures consistent with their national law to protect the confidentiality of any information which they receive in confidence by virtue of the provisions of this convention from another state party or through participation in an activity carried out for the implementation of this convention. If states parties provide information to international organizations in confidence, steps shall be taken to ensure that the confidentiality of such information is protected. 3. States parties shall not be required by this convention to provide any information which they are not permitted to communicate pursuant to national law or which would jeopardize the security of the state concerned or the physical protection of nuclear material. 4. States parties shall inform the Secretary-General of the United Nations of their competent authorities and liaison points responsible for sending and receiving the information referred to in the present article. The Secretary-General of the United Nations shall communicate such information regarding competent authorities and liaison points to all states parties and the International Atomic Energy Agency. Such authorities and liaison points must be accessible on a continuous basis. Article 8. For purposes of preventing offenses under this convention, states parties shall make every effort to adopt appropriate measures to ensure the protection of radioactive material, taking into account relevant recommendations and functions of the International Atomic Energy Agency. Article 9. 1. Each state party shall take such measures as may be necessary to establish its jurisdiction over the offenses set forth in Article 2 when a. The offense is committed in the territory of that state, or b. The offense is committed on board a vessel flying the flag of that state or an aircraft which is registered under the laws of that state at the time the offense is committed, or c. The offense is committed by a national of that state. 2. A state party may also establish its jurisdiction over any such offense when a. The offense is committed against a national of that state, or b. The offense is committed against a state or government facility of that state abroad, including an embassy or other diplomatic or consular premises of that state, or c. The offense is committed by a stateless person who has his or her habitual residence in the territory of that state, or d. The offense is committed in an attempt to compel that state to do or abstain from doing any act, or e. The offense is committed on board an aircraft which is operated by the government of that state. 3. Upon ratifying, accepting, approving or acceding to this convention, each state party shall notify the Secretary-General of the United Nations of the jurisdiction it has established under its national law in accordance with paragraph 2 of the present article. Should any change take place, the state party concerned shall immediately notify the Secretary-General. 4. Each state party shall likewise take such measures as may be necessary to establish its jurisdiction over the offenses set forth in Article 2 in cases where the alleged offender is present in its territory and it does not extradite that person to any of the states parties which have established their jurisdiction in accordance with paragraph 1 or 2 of the present article. 5. This convention does not exclude the exercise of any criminal jurisdiction established by a state party in accordance with its national law. Article 10, 1. Upon receiving information that an offense set forth in Article 2 has been committed or is being committed in the territory of a state party, or that a person who has committed or who is alleged to have committed such an offense may be present in its territory, the state party concerned shall take such measures as may be necessary under its national law to investigate the facts contained in the information. 2. Upon being satisfied that the circumstances so warrant, the state party in whose territory the offender or alleged offender is present shall take the appropriate measures under its national law so as to ensure that persons present for the purpose of prosecution or extradition. 3. Any person regarding whom the measures referred to in paragraph 2 of the present article are being taken shall be entitled a. To communicate without delay with the nearest appropriate representative of the state of which that person is a national, or which is otherwise entitled to protect that person's rights, or, if that person is a stateless person, the state in the territory of which that person habitually resides. b. To be visited by a representative of that state. c. To be informed of that person's rights under subparagraphs a and b. 4. The rights referred to in paragraph 3 of the present article shall be exercised in conformity with the laws and regulations of the state in the territory of which the offender or alleged offender is present, subject to the provision that the said laws and regulations must enable full effect to be given to the purposes for which the rights accorded under paragraph 3 are intended. 5. The provisions of paragraphs 3 and 4 of the present article shall be without prejudice to the right of any state party having a claim to jurisdiction in accordance with Article 9, paragraph 1, c, or 2c. To invite the International Committee of the Red Cross to communicate with and visit the alleged offender. 6. When a state party, pursuant to the present article, has taken a person into custody, it shall immediately notify, directly or through the Secretary-General of the United Nations, the states parties which have established jurisdiction in accordance with Article 9, paragraphs 1 and 2, and, if it considers it advisable, any other interested states parties, of the fact that that person is in custody and of the circumstances which warrant that person's detention. The state which makes the investigation contemplated in paragraph 1 of the present article shall promptly inform the said states parties of its findings and shall indicate whether it intends to exercise jurisdiction. Article 11, 1. The state party in the territory of which the alleged offender is present shall, in cases to which Article 9 applies, if it does not extradite that person, be obliged, without exception whatsoever and whether or not the offense was committed in its territory, to submit the case without undue delay to its competent authorities for the purpose of prosecution, through proceedings in accordance with the laws of that state. Those authorities shall take their decision in the same manner as in the case of any other offense of a grave nature under the law of that state. 2. Whenever a state party is permitted under its national law to extradite or otherwise surrender one of its nationals only upon the condition that the person will be returned to that state to serve the sentence imposed as a result of the trial or proceeding for which the extradition or surrender of the person was sought, and this state and the state seeking the extradition of the person agree with this option and other terms they may deem appropriate, such a conditional extradition or surrender shall be sufficient to discharge the obligation set forth in paragraph 1 of the present article. Article 12. Any person who is taken into custody or regarding whom any other measures are taken or proceedings are carried out pursuant to this convention shall be guaranteed fair treatment, including enjoyment of all rights and guarantees in conformity with the law of the state in the territory of which that person is present and applicable provisions of international law, including international law of human rights. Article 13, 1. The offences set forth in Article 2 shall be deemed to be included as extraditable offences in any extradition treaty existing between any of the states parties before the entry into force of this convention. States parties undertake to include such offences as extraditable offences in every extradition treaty to be subsequently concluded between them. 2. When a state party which makes extradition conditional on the existence of a treaty receives a request for extradition from another state party with which it has no extradition treaty, the requested state party may, at its option, consider this convention as a legal basis for extradition in respect of the offences set forth in Article 2. Extradition shall be subject to the other conditions provided by the law of the requested state. 3. States parties which do not make extradition conditional on the existence of a treaty shall recognize the offences set forth in Article 2 as extraditable offences between themselves, subject to the conditions provided by the law of the requested state. 4. If necessary, the offences set forth in Article 2 shall be treated, for the purposes of extradition between states parties, as if they had been committed not only in the place in which they occurred but also in the territory of the states that have established jurisdiction in accordance with Article 9, paragraphs 1 and 2. 5. The provisions of all extradition treaties and arrangements between states parties with regard to offences set forth in Article 2 shall be deemed to be modified as between states parties to the extent that they are incompatible with this convention. Article 14, 1. States parties shall afford one another the greatest measure of assistance in connection with investigations or criminal or extradition proceedings brought in respect of the offences set forth in Article 2, including assistance in obtaining evidence at their disposal necessary for the proceedings. 2. States parties shall carry out their obligations under paragraph 1 of the present article in conformity with any treaties or other arrangements on mutual legal assistance that may exist between them. In the absence of such treaties or arrangements, states parties shall afford one another assistance in accordance with their national law. Article 15. None of the offences set forth in Article 2 shall be regarded, for the purposes of extradition or mutual legal assistance, as a political offence or as an offence connected with a political offence or as an offence inspired by political motives. Accordingly, a request for extradition or for mutual legal assistance based on such an offence may not be refused on the sole ground that it concerns a political offence or an offence connected with a political offence or an offence inspired by political motives. Article 16. Nothing in this convention shall be interpreted as imposing an obligation to extradite or to afford mutual legal assistance if the requested state party has substantial grounds for believing that the request for extradition for offences set forth in Article 2 or for mutual legal assistance with respect to such offences has been made for the purpose of prosecuting or punishing a person on account of that person's race, religion, nationality, ethnic origin or political opinion, or that compliance with the request would cause prejudice to that person's position for any of these reasons. Article 17. 1. A person who is being detained or is serving a sentence in the territory of one state party whose presence in another state party is requested for purposes of testimony, identification or otherwise providing assistance in obtaining evidence for the investigation or prosecution of offences under this convention may be transferred if the following conditions are met. A. The person freely gives his or her informed consent and B. The competent authorities of both states agree, subject to such conditions as those states may deem appropriate. 2. For the purposes of the present article, A. The state to which the person is transferred shall have the authority and obligation to keep the person transferred in custody, unless otherwise requested or authorized by the state from which the person was transferred. B. The state to which the person is transferred shall without delay implement its obligation to return the person to the custody of the state from which the person was transferred as agreed beforehand, or as otherwise agreed, by the competent authorities of both states. C. The state to which the person is transferred shall not require the state from which the person was transferred to initiate extradition proceedings for the return of the person. D. The person transferred shall receive credit for service of the sentence being served in the state from which he or she was transferred for time spent in the custody of the state to which he or she was transferred. 3. Unless the state party from which a person is to be transferred in accordance with the present article so agrees, that person, whatever his or her nationality, shall not be prosecuted or detained or subjected to any other restriction of his or her personal liberty in the territory of the state to which that person is transferred in respect of acts or convictions anterior to his or her departure from the territory of the state from which such person was transferred. Article 18. 1. Upon seizing or otherwise taking control of radioactive material, devices or nuclear facilities, following the commission of an offense set forth in Article 2, the state party in possession of such items shall a. Take steps to render harmless the radioactive material, device or nuclear facility. b. Ensure that any nuclear material is held in accordance with applicable International Atomic Energy Agency safeguards and c. Have regard to physical protection recommendations and health and safety standards published by the International Atomic Energy Agency. 2. Upon the completion of any proceedings connected with an offense set forth in Article 2, or sooner if required by international law, any radioactive material, device or nuclear facility shall be returned, after consultations, in particular, regarding modalities of return and storage, with the states parties concerned to the state party to which it belongs, to the state party of which the natural or legal person owning such radioactive material, device or facility is a national or resident, or to the state party from whose territory it was stolen or otherwise unlawfully obtained. 3. A. Where a state party is prohibited by national or international law from returning or accepting such radioactive material, device or nuclear facility, or where the states parties concerned so agree, subject to paragraph 3b of the present article, the state party in possession of the radioactive material, devices or nuclear facilities shall continue to take the steps described in paragraph 1 of the present article. Such radioactive material, devices or nuclear facilities shall be used only for peaceful purposes. B. Where it is not lawful for the state party in possession of the radioactive material, devices or nuclear facilities to possess them, that state shall ensure that they are placed as soon as possible in the possession of a state for which such possession is lawful, and which, where appropriate, has provided assurances consistent with the requirements of paragraph 1 of the present article in consultation with that state, for the purpose of rendering it harmless. Such radioactive material, devices or nuclear facilities shall be used only for peaceful purposes. 4. If the radioactive material, devices or nuclear facilities referred to in paragraphs 1 and 2 of the present article do not belong to any of the states parties, or to a national or resident of a state party, or was not stolen or otherwise unlawfully obtained from the territory of a state party, or if no state is willing to receive such items pursuant to paragraph 3 of the present article, a separate decision concerning its disposition shall, subject to paragraph 3b of the present article, be taken after consultations between the states concerned and any relevant international organizations. 5. For the purposes of paragraphs 1, 2, 3 and 4 of the present article, the state party in possession of the radioactive material, device or nuclear facility may request the assistance and cooperation of other states parties, in particular the states parties concerned, and any relevant international organizations, in particular the International Atomic Energy Agency. States parties and the relevant international organizations are encouraged to provide assistance pursuant to this paragraph to the maximum extent possible. 6. The states parties involved in the disposition or retention of the radioactive material, device or nuclear facility pursuant to the present article shall inform the Director General of the International Atomic Energy Agency of the manner in which such an item was disposed of or attained. The Director General of the International Atomic Energy Agency shall transmit the information to the other states parties. 7. In the event of any dissemination in connection with an offense set forth in Article 2, nothing in the present article shall affect in any way the rules of international law governing liability for nuclear damage, or other rules of international law. Article 19. The state party where the alleged offender is prosecuted shall, in accordance with its national law or applicable procedures, communicate the final outcome of the proceedings to the Secretary-General of the United Nations, who shall transmit the information to the other states parties. Article 20. States parties shall conduct consultations with one another directly or through the Secretary-General of the United Nations, with the assistance of international organizations as necessary, to ensure effective implementation of this convention. Article 21. The states parties shall carry out their obligations under this convention in a manner consistent with the principles of sovereign equality and territorial integrity of states, and that of non-intervention in the domestic affairs of other states. Article 22. Nothing in this convention entitles a state party to undertake in the territory of another state party the exercise of jurisdiction and performance of functions which are exclusively reserved for the authorities of that other state party by its national law. Article 23. 1. Any dispute between two or more states parties concerning the interpretation or application of this convention which cannot be settled through negotiation within a reasonable time shall, at the request of one of them, be submitted to arbitration. If, within 6 months of the date of the request for arbitration, the parties are unable to agree on the organization of the arbitration, any one of those parties may refer the dispute to the International Court of Justice, by application, in conformity with the statute of the court. 2. Each state may, at the time of signature, ratification, acceptance or approval of this convention or accession thereto, declare that it does not consider itself bound by paragraph 1 of the present article. The other states' parties shall not be bound by paragraph 1 with respect to any state party which has made such a reservation. 3. Any state which has made a reservation in accordance with paragraph 2 of the present article may at any time withdraw that reservation by notification to the Secretary-General of the United Nations. Article 24, 1. This convention shall be open for signature by all states from the 14th of September 2005 until the 31st of December 2006 at United Nations headquarters in New York. 2. This convention is subject to ratification, acceptance or approval. The instruments of ratification, acceptance or approval shall be deposited with the Secretary-General of the United Nations. 3. This convention shall be open to accession by any state. The instruments of accession shall be deposited with the Secretary-General of the United Nations. Article 25, 1. This convention shall enter into force on the 30th day following the date of the deposit of the 22nd instrument of ratification, acceptance, approval or accession with the Secretary-General of the United Nations. 2. For each state ratifying, accepting, approving or acceding to the convention after the deposit of the 22nd instrument of ratification, acceptance, approval or accession, the convention shall enter into force on the 30th day after deposit by such state of its instrument of ratification, acceptance, approval or accession. Article 26, 1. A state party may propose an amendment to this convention. The proposed amendment shall be submitted to the depository, who circulates it immediately to all states parties. 2. If the majority of the states parties request the depository to convene a conference to consider the proposed amendments, the depository shall invite all states parties to attend such a conference to begin no sooner than 3 months after the invitations are issued. 3. The conference shall make every effort to ensure amendments are adopted by consensus. Should this not be possible, amendments shall be adopted by a 2/3 majority of all states parties. Any amendment adopted at the conference shall be promptly circulated by the depository to all states parties. 4. The amendment adopted pursuant to paragraph 3 of the present article shall enter into force for each state party that deposits its instrument of ratification, acceptance, accession or approval of the amendment on the 30th day after the date on which 2/3 of the states parties have deposited their relevant instrument. Thereafter, the amendment shall enter into force for any state party on the 30th day after the date on which that state deposits its relevant instrument. Article 27, 1. Any state party may denounce this convention by written notification to the Secretary-General of the United Nations. 2. Denunciation shall take effect 1 year following the date on which notification is received by the Secretary-General of the United Nations. Article 28. The original of this convention, of which the Arabic, Chinese, English, French, Russian and Spanish texts are equally authentic, shall be deposited with the Secretary-General of the United Nations, who shall send certified copies thereof to all states. In witness whereof, the undersigned, being duly authorized thereto by their respective governments, have signed this convention, opened for signature at United Nations headquarters in New York on the 14th of September 2005.